This, our sixth and final session, will deal with Executive Order of November 13th, 2001, creating military tribunals. We'll also deal with other executive orders in times of crisis. And with a dangerous potential I call the creation of an underclass, or crimes of status. This is a phenomenon to which I think we must all become sensitized, especially during times of national crisis. Now, there's a tale to which I kept coming back as I worked on preparing this session. It's about a doukhobor. Now, I can see you're all nodding your heads. Of course, everybody knows what a doukhobor is, but frankly, I had to run the encyclopedia. But for those few of us who, like me, needed educating, a doukhobor was a member of an orgiastic cult, which apparently originated in central Russia in the 18th century. Now, the doukhobors were a rather wild bunch with many strange and eccentric habits and views. They were ostracized by their countrymen in Russia, and many fled abroad to countries such as England, where in championing various occult causes, they were known to commit acts of arson. But the doukhobors were stubborn cusses, and when arson didn't do the trick and they didn't get their way, they were prone to parade naked in the streets. At the commencement of a chapter on the infamous Palmer-raids of 1920, Zechariah Chafee, in his classic work on civil liberties, Free Speech in the United States, quotes the following anecdote regarding the doukhobors from author Charles P. Howland. The doukhobor tried to go naked in the streets of London. A policeman set out gravely to capture him, but found himself distanced because of his heavy clothing. Therefore, he divested himself as he ran of garment after garment, until he was naked. And so lightened, he caught his prey. But then it was impossible to tell which was the doukhobor and which was the policeman. On October 26, 2001, barely 6 weeks after the horrific events of September 11th, following intense but swift debate, the House and the Senate passed, and the President signed into law, Public Law Number 107-56, a 342-page act with a very long name. It's entitled Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism, Act of 2001. The Act is more commonly known by its acronym, the USA Patriot Act. The Act is what its formal title implies, a broad expansion of prosecutorial tools urgently requested by the administration to enable it to deal with suspected terrorists in our midst. The Act contained, among other measures, a significant expansion of executive authority, largely unchecked, to track email and internet usage, including the use by the FBI of the highly sophisticated carnivore email interception system. It also enhanced the executive's ability to obtain sensitive personal records and circumvent many Fourth Amendment search and seizure requirements. Significantly, it also broke down many of the barriers previously established in FISA, the Foreign Intelligence Surveillance Act, for the sharing of information between criminal and intelligence agencies. This has caused some to fear a resurgence of domestic spying by the CIA and a reversion to the dark period we endured under Richard Nixon. Someone last week asked what were the statutory enactments after Nixon to try to prevent that. FISA was one. The constitutionality of all this, of course, will be played out in the courts in the not-too-distant future. More to the issues I'm going to focus on here. The act which was passed did not quite grant to the president the full range of statutory powers he had apparently requested. Newsweek reported that the secret first draft of the anti-terrorism bill presented by Ashcroft Justice Department contained a section entitled Suspension of the Writ of Habeas Corpus. But Congress had quickly eliminated this. In fact, Congress provided a section 236AB7 entitled Habeas Corpus and Judicial Review, which specifically empowered an alien who had been apprehended to petition the court for a writ of habeas corpus to review the determination of the Attorney General of the grounds of his detention. Well, Congress, therefore, was stunned when, having failed to get all the requested statutory authority, the administration barely 2 weeks later, on November 13, 2001, simply issued a military order. It was entitled Detention, Treatment, and Trial of Certain Non-Citizens in the war against terrorism. The order permits the executive to detain aliens, hold them indefinitely without charges or trial, without the right to seek a remedy in federal or state courts. In fact, the administration in one bold sweep, notwithstanding the provisions of pronouncements of Congress on the subject, purportedly, 1, abolished the writ of habeas corpus as to such aliens, and 2, established an underclass, membership in which became a crime of status. And these two aspects of the order will be my focus in this section. Well, how does the order create an underclass? Well, international law contemplates reliance on military justice in a zone of combat. Arguably, we have or had such a zone in Afghanistan, and Taliban and al-Qaeda fighters captured there in the caves of Tora Bora and transported to Guantanamo Bay would surely appear to fit that description. But the order is not so confined. The order defines an individual subject to this order as any individual who is not a United States citizen with respect to whom I, the President, determine from time to time in writing that there is reason to believe is a member of al-Qaeda, has engaged in, aided, or abetted, or conspired to commit acts of international terrorism, and these acts are then elaborated in some detail. The phrase, any individual with respect to whom I determine, creates an underclass. The order in one broad sweep eliminates habeas corpus and wipes out the separation of powers as it applies to all non-citizens, including, of course, over 18 million aliens residing in the United States. The President, in this case in the form of the Department of Defense, decides who to detain, how long to detain them, and whether or not and who to prosecute. The executive, thus unrestrained, establishes the procedural rules and both prosecutes the cases and exercises the judicial power of judge and jury, finding the facts, deciding the law. As originally issued, there was no possible appeal to the judicial branch, only to the executive, unlike even the rules for certain courts-martial, where appeal may be had to the judicial branch. The bulk of the remaining provisions of the order relating to such aliens were intentionally made inconsistent with the essential elements of due process provided in the Constitution and in the Uniform Code of Military Justice. Evidentiary rules were suspended. Instead, evidence having a probative value to a reasonable person in the opinion of the presiding officer, that's Section 4C3, is made admissible. Classified or classifiable evidence may be protected from disclosure to defense counsel and hence is not subject to cross-examination. The handling of the admission of such evidence, again, being exclusively in the discretion of the presiding officers who become both judge and jury. This is as initially issued on November 13th. Conviction and sentencing is upon concurrence of only 2/3 of the members of the Military Commission, and appeal is only to the President or the Secretary of Defense if so designated by the President. This is as originally issued. The punishment which can be meted out to the members of the underclass in this matter, without any right of habeas corpus or appeal to the civilian courts, is the most severe imaginable. It includes life imprisonment and death. Finally, in a sweeping catch-all provision, as if the drafter were concerned that he had not already fully eliminated all traces of habeas corpus and due process, Section 7B2 of the order provides that the individual subject to its reach shall not be privileged to seek any remedy or maintain any proceeding directly or indirectly, or to have any such remedy or proceeding sought on the individual's behalf in any court of the United States or state thereof. Was this executive order impetuous, unneeded, unjustified, overreaching? Historically, our presidents have proved ruthless in suppressing civil liberties when our society or the nation is threatened. Remember Mark Neely pointed out with respect to the suspension of habeas corpus by Lincoln in an even broader class. Lincoln would eventually counter theory with theory, but would act as needed in the meantime. The administration in November 2001 was faced with a terror threat to the homeland heretofore unknown to us. When you're in command and responsible for the safety of the entire nation, and it's an imminent danger from dedicated, clever, but suicidal terrorists, both unseen and unknown, theory tends to take a back seat. Remember, all of this was happening only 8 weeks after September 11th. But what happened then is gripping. Following the issuance of the order, Congress reacted with alarm. It had just been overridden by executive fiat. The constitutional balance of power was clearly under attack here. At the hearings of the Senate Judiciary Committee that ensued, the Attorney General was called to task. John Ashcroft testified, dramatically waving an Al-Qaeda training manual, and declared, quote, "To those who scare peace-loving people with phantoms of lost liberty, my message is this: your tactics only aid terrorists and diminish our resolve." Now, this phrase has been interpreted and reinterpreted in the press 1,000 times. Some commentators implied that it was an attempt to label anyone who questioned the administration's order as unpatriotic, shades of the sedition mindset evidenced in Haldeman's interview with Barbara Walters, which we reviewed last week. Ashcroft vigorously denied that this was his intention. Frankly, reading Ashcroft's message in the context of all his other remarks, I'm not sure. But if this was Ashcroft's intention, I can only quote essayist Roger Rosenblatt in rebuttal. Rosenblatt wrote an essay entitled, "But We're Extremely Disloyal." And in that essay, he alleges that one of the delights of this country is that it has disloyalty built into its system. That is because the intelligently disloyal subject knows when to go against the grain and when to harvest it. He then tells the following story. During the McCarthy shame, graduate students were required to sign loyalty oaths when they applied for government grants. Some of you may remember that. A dean at Harvard defended this practice as being merely pro forma, of no greater significance, he said, than licking the stamps on application envelopes. At a faculty meeting, the great Italian scholar Renato Poggioli stood up and commented, "Hey, Mr. Dean, I am from a fascista Italy, and I will tell you something. First you lick at the stamps, then you lick at something else." Ashcroft did, however, promise that guidelines to be issued by the Department of Defense in the form of regulations would modify the order. Media coverage was intense, and debates raged on television and the print media among constitutional scholars and others as to whether the order should be allowed to stand. So much came out that it was hard to keep up with it all. And it's to the great credit of this country that such battles raged, notwithstanding that the country was simultaneously undergoing an anthrax scare. Bin Laden is certainly still at large, and security measures were still less than effective at airports and elsewhere. I feel heartened by that reaction and that debate. Administration officials, of course, sprang to the defense of the order. In an op-ed piece in the New York Times on November 30th, 2001, entitled "Martial Justice, Full and Fair," Judge Alberto Gonzalez, counsel to the president, sought to reassure the public that trials held under the order would be just that, full and fair. The American military justice system is the finest in the world, alleged Judge Gonzalez, with long-standing traditions forbidding command influence on proceedings and of procedural fairness. Well, perhaps so, Judge Gonzalez, but these were not proceedings under the Uniform Code of Military Justice. These were not courts-martial proceedings. He then went on to insist that the order provides for review in the civilian courts, which it clearly does not. I just read you that provision. And that challenges could be made to the tribunal's jurisdiction through habeas corpus proceedings, which of course the order specifically forbids. Finally, he points out that the language of the order is similar to the language of a military tribunal order issued by FDR, which it is. And that FDR's order was construed by the Supreme Court to permit habeas corpus, which it was not. The Supreme Court in the Quirin case, in fact, granted habeas corpus and heard the matter over the government's objection, in effect holding that the language of the order, which sought to deny habeas corpus, was unconstitutional. Now, the Military Affairs Committee of the New York City Bar Association issued a detailed report on the order in December 2001. And the American Bar Association soon thereafter adopted its recommendations almost verbatim by resolution. Just last week, the New York State Bar Association committee studying this matter reached identical conclusions. Now, the city bar report was entitled Inter Armas Silent Leges. It's an old Roman phrase meaning in the time of war, law is silent. makes the point that the Constitution protects foreigners within our jurisdiction, but not those who encounter our troops in combat abroad. It recommended that for use abroad, the alternative most acceptable to military tribunals would undoubtedly be courts-martial under the Uniform Code of Military Justice. Domestically, the preferable alternative for all trials for violations of the laws of war would be the federal courts. The report concluded that domestic courts could be made sufficiently secure for trial of civilian-type defendants likely to be apprehended in the United States. Alleged violations of the laws of war could be tried domestically under the Uniform Code of Military Justice. Most importantly, it urged that detainees, such as the unfortunate described in that Kafkaesque New York Times Magazine article yesterday, which many of you may have read, should not be detained indefinitely. They should be entitled to petition for their release, including certiorari, that is a right of appeal discretionary with the Supreme Court, and the right to petition for a writ of habeas corpus. Eventually, on March 22, 2002, after intense public debate and under considerable pressure in the press and elsewhere, the Department of Defense released rules which modified the order in certain very significant respects. The rules adopt a number of the provisions of the Uniform Code of Military Justice and civilian trial structure. They provide, for example, for the presumption of innocence, limited defense discovery of prosecution evidence, and exculpatory evidence. Tribunals will now be mostly open to the press and public, although the presiding officer, not unlike federal judges in this respect, is given wide latitude to close them. Well, so are the federal courts. Moussaoui case is closed. Guilt must be established beyond a reasonable doubt, as in criminal trials, and the death penalty must now be decided upon unanimously by a 7-member panel, just as in trials by courts-martial. Other convictions may still be by 2/3 majority, also paralleling the standard in trial by courts-martial. The new rules allow defendants to replace an assigned military lawyer or hire civilian defense counsel. They now require that at least one member of the appeals panel be a military or civilian judge, and they provide that civilian legal experts may be appointed to the panel through a temporary military commission. All of these modifications and numerous others, wrought no doubt by the strong reaction of the public and Congress, apparently unanticipated by the administration, softened the broadside leveled on due process by the initial administration fiat. But where do we go from here with these tribunals? The history of military tribunals in the current terrorist crisis has not yet been written. So far, they have not been used. If tribunals are used, there may be many more modifications arising out of their use in actual practice, and the courts have yet to speak with regard to the constitutionality of the order in whole or in part. Volumes have been and are being written on this subject, and we could easily spend an entire course analyzing each and every aspect of the order and of the USA Patriot Act, all 320 pages of it, in the light of our constitutional history and the current crisis. But I've chosen to limit our consideration here today to an analysis of the order alone, and specifically to its suspension of habeas corpus and its creation of an underclass, a crime of status, for a number of reasons. One, this is a manageable topic within our time frame. Two, we've had experience with both of these elements in our history. We have, in fact, dealt with both in these sessions. Three, although the suspension of many other elements of due process by the order, even as now modified by the regulations, is of course problematic, these two elements of the order have deep roots, and to me are the most threatening to all our basic freedoms. And finally, the potential use of such tribunals highlights the complexity of the battle between the needs of security and the burdens of freedom that we must deal with and learn to balance in a free society. And it highlights as well something I have insisted throughout these sessions: there are no simple solutions here. Well, then how does the order of November 13th purport to suspend habeas corpus? Well, Section 3 of the order, entitled Detention Authority of the Secretary of Defense, authorizes the Secretary of Defense to detain such persons as are so determined by the President. The section, by the way, provides for very humane treatment for such detainees. But what is not dealt with is the fact that the Secretary may detain and hold any alien indefinitely, without the alien being able to test the validity or the constitutionality of the detention in the court system. In fact, that right is specifically prohibited in Section 7B2 of the order in so many words, lifted almost verbatim from a proclamation of FDR issued July 2, 1942. Now, you'll recall from our second session that habeas corpus is the name given to a variety of writs having as their object to bring a party before a court or a judge. But isn't alien entitled to the right of habeas corpus? Supreme Court's consistently held that aliens are entitled to this right. Let's take a look at three of the cases that have so held: Wong Wing versus the United States, Ex parte Quirin, and In re Yamashita. In 1896, the Supreme Court held that the Circuit Court erred in not discharging prisoner Wong Wing, a Chinese alien. Wong Wing had been tried in Michigan by a commission and sentenced to prison under an act of Congress of May 4, 1892. Court held that Wong Wing was not only entitled to a writ of habeas corpus, but he had the right to challenge the constitutionality of the statute itself. The court then went on to hold that the act of Congress was in violation of the constitutional right to present before an indictment by a grand jury in case one is charged with an infamous crime or misdemeanor, as provided in the Fifth and Sixth Amendments of the Constitution. But it decided further that aliens within the territory of the United States are entitled to protection of the Fifth and Sixth Amendments. For you lawyers present, the site is 163 U.S. 228, 1896. There are numerous similar precedents in which the court has reaffirmed that aliens are persons entitled to the protections of the Fifth and Sixth Amendments, and that the protections are not to be confined to citizens alone. Perhaps the most trenchant examples of the reverence our Supreme Court has for the writ, however, are the cases of Ex parte Quirin and In re Yamashita. Here the court recognized the right even of alleged spies, members of the German military, and of the Japanese command within U.S. territory to test the authority of the military commissions established to try them by habeas corpus proceedings. In both cases, by the way, the defendants were convicted, and in the case of 6 of the 8 Quirin defendants and of General Yamashita, they were executed. But in both cases, the court recognized their right to petition in habeas corpus, which is the operative fact for our purposes. Just after the United States entered the Second World War, the Nazi intelligence service known as the Abwehr came under great pressure from Adolf Hitler to disrupt U.S. war production efforts and to cause chaos and confusion on the home front here. It planned successive waves of terror attacks on our shores. In June 1942, 8 Germans who had received training in sabotage at a school near Berlin boarded submarines and landed on our shores. 4 in Amagansett Beach, Long Island, 4 at Ponte Verde, Florida. Now, the Amagansett 4 promptly buried their German infantry caps upon landing and proceeded to various points in the United States, carrying with them explosives and timing devices. Not before an unarmed Coast Guardsman patrolling fog-ridden Amagansett Beach spotted the unlucky 4 who landed in Amagansett. They explained to him they were just fishermen waiting for the fog to clear. But just then, unfortunately for them, one of the men called out to the leader in German, whereupon the German leader of the group offered the frightened Coast Guardsman a $300 bribe if he would forget that he ever saw them. Well, he took the $300, no dummy he, but did not forget, and reported the incident to the FBI. The FBI, of course, did nothing about it. It seems they never learn. Nothing changes. Well, the group of 4 then proceeded to New York City, where 2 of their number put up at the Governor Clinton Hotel, still there, and discovered to each other's amazement that they both had intended to turn themselves over to the FBI. The hilarity continues, because they promptly attempted to do just that. Again, the FBI was incredulous, believing the Germans to be just another crank caller. So in desperation, the Germans traveled to Washington, appeared at the office of the FBI, dumped $80,000 in cash on the table. At this point, the FBI finally awoke from its prolonged slumber. When he learned of the incursion on our shores, President Roosevelt was livid and demanded swift and severe punishment. J. Edgar Hoover was greatly embarrassed that the FBI had failed to apprehend the saboteurs on 2 occasions, even when they'd called the FBI to turn themselves in. He prevailed on FDR not to reveal this fact. And as we know, FDR agreed because Hoover had his way with presidents. And so the rush was on, not only to judgment, but to secrecy. The problem was complicated by the fact that two of the Germans claimed American citizenship. There was concern that trial and punishment before a civilian court would be too slow, present evidentiary problems. After all, crimes such as espionage and treason are difficult to prove. Perhaps more to the point, a public trial would also expose the bungling of the FBI. J. Edgar Hoover, at a press conference, had already reported that the arrest of the saboteurs was another outstanding FBI coup. And his announcement had predictably produced outrage at the Nazi incursion onto our soil. Without how then to achieve secrecy and speed? The solution was to issue a presidential proclamation and order, and FDR obliged immediately on July 2, 1942, issuing the proclamation and order alluded to by Judge Gonzales in his op-ed piece. The proclamation denied the defendants access to a civilian court. The order provided that the defendants would be tried by a military commission to be conducted in secret. Evidence that merely had probative value to a reasonable man, remember that language, would be admissible. The president himself would make the final decision after receiving the commission's recommendations, and there would be no appeal. Sound familiar? It should. It was lifted by the present administration almost verbatim on the November 13, 2001 order as it originally stood. The petitioners were assigned very capable military counsel who advised FDR that they intended to file habeas corpus proceedings. Francis Biddle later recounted that FDR had said to him, "I want one thing clearly understood, Francis. I won't give them up. I won't turn them over to any United States Marshal armed with a writ of habeas corpus. Understood?" And things then proceeded in haste. The commission convened only 11 days after the last saboteur was arrested. Colonel Kenneth Royal, an experienced and capable trial lawyer, later to become a prominent Wall Street lawyer, many of you lawyers here may know the firm Royal Cagle, was assigned to represent all but one of the defendants, an able lawyer. Royal moved in the midst of the trial for leave to file petitions for writs of habeas corpus, challenging the constitutionality of the order. He contended on behalf of the petitioners that the president was without any statutory or constitutional authority to order the petitioners tried in a secret military commission. He alleged that they were entitled to be tried in the civil courts with safeguards afforded by the Fifth and Sixth Amendments, including trial by jury. And he cited the post-Civil War Milligan case as a precedent. Milligan, you will recall, held that a military commission could not try civilians unless civil courts were closed and martial law imposed, neither of which condition obtained here in 1942. You may recall that Milligan was a civilian in Indiana and civilian courts were open. The court, in a per curiam decision issued the day after the argument, denied the writs, ruling that the charges against the petitions were triable by military commission. Per curiam simply means a brief announcement just of the decision in the case, with reasons and a written opinion, if any, to follow. The detailed written opinion finally did come down 3 months after 6 of the defendants had already been executed and 2 sentenced to prison. The essence of the opinion lay in the finding that since the saboteurs had buried their uniforms, changed into civilian clothes, they became belligerents, not entitled to the status of prisoners of war. They were, therefore, in the words of the court, offenders against the laws of war, subject to trial and punishment by military tribunals. Congress had provided specifically for military tribunals by enacting the Articles of War, first codified in the U.S. Code in 1926. Now, also the court pointed out that it has not been seriously challenged in the literature on the subject that an alien spy in time of war can be tried by a military tribunal. Thus, without actually overruling Milligan, the court found sufficient factual differences to distinguish it. The defendant in Milligan, of course, was a civilian. But although the court denied the petitioner's writ, in its decision, the court rejected FDR's edict that there could be no access to the civil courts. And this is the defining point for purposes of our discussion here. And here's what the court said, quote, "It is urged by the government that if they are enemy aliens or if the proclamation of FDR has no force no court may afford petitioners a hearing, but there is certainly nothing in the proclamation to preclude access to the courts for determining its applicability to the particular case. And neither the proclamation nor the fact that they were enemy aliens forecloses consideration by the courts of petitioners' contentions that the Constitution and the laws of the United States constitutionally enacted forbid their trial by military commission. The case, incidentally, for you lawyers is Ex parte Queering 317 U.S. 1 at page 25. In other words, even alleged enemy saboteurs in a declared war cannot be denied the right to petition in habeas corpus. The court, although it denied their appeals on the merits, did not deny their right to appeal through our civilian court system. Think of it. The Supreme Court in Queering upheld the right even of alleged alien enemy saboteurs in wartime to petition our court for a writ of habeas corpus to contest the jurisdiction of the military commission to try them. The order of November 13, 2001 has provisions nearly identical to those in the FDR 1942 proclamation in question in the Queering case. The FDR proclamation in Queering provides, quote, such persons, citizens of countries at war with the United States, shall not be privileged to seek any remedy or proceeding directly or indirectly, or to have any such remedy or proceeding sought on their behalf in the courts of the United States. Sound identical? Sound familiar? It is. It was right in the November 13th order. This particular aspect of the proclamation, which sought to suspend habeas corpus, was thus ruled unconstitutional in Queering. Despite the protestations of Judge Gonzalez on behalf of the administration, the nearly identical provisions in the executive order of November 13th may well be held unconstitutional as well, if and when they're tested. General Tomoyuki Yamashita was the commanding general of the 14th Army Group of the Imperial Japanese Army in the Philippine Islands during the Second World War. On September 3, 1945, he surrendered to the United States Army at Bagayo, Luzon, and immediately became a prisoner of war. A military commission was appointed to try General Yamashita on a charge of violation of the law of war. The gist of the charge was that he had failed in his duty to prevent his troops from committing atrocities by permitting the massacre and extermination of a large part of the civilian population of Batangas province. It was contended by counsel for Yamashita, and he had good representation too, that due to the swift advance of Allied forces after the American victory in the island of Leyte and during the invasion of Luzon, the communication, discipline, and morale of his troops had disintegrated. Thereafter, the troops failed to obey his orders, resulting in the subsequent massacre. His defense was deemed insufficient by the tribunal. Yamashita was found guilty and sentenced to hang. Counsel for Yamashita applied for leave to file a petition for writs of habeas corpus, challenging the jurisdiction and the legal authority of the military commission which had tried and convicted him. Although the petition was denied, the Supreme Court nonetheless held that by sanctioning trials of enemy aliens by military commission for offenses against the law of war, Congress recognized the right of the accused to make a defense and did not foreclose his right to contend that the Constitution or the laws of the United States withhold authority to proceed with a trial. Perhaps the most poignant pronouncement from the court on the subject of habeas corpus was the following statement by Justice Murphy dissenting in the Yamashita case. The obnoxious doctrine asserted by the government in this case to the effect that restraints of liberty resulting from military trials of war criminals are political matters completely outside the arena of judicial review has been rejected fully and unquestionably. When the liberty of any person is restrained by reason of the authority of the United States, the writ of habeas corpus is available to test the legality of the restraint. And later, no exception is made as to those who are accused of war crimes or as to those who possess the status of enemy belligerent. Indeed, such an exception will be contrary to the whole philosophy of human rights, which makes the Constitution the great living document that it is. The immutable rights of the individual, including those secured by the Due Process Clause of the Fifth Amendment, rise above any status of belligerency or outlawry. They survive any popular passion or frenzy of the moment. It's quite an eloquent defense of the classic writ. Unfortunately, it was in a dissenting opinion, but essentially the opinion held the same thing. The order of November 13, 2001 lists the President's authority as Commander-in-Chief of the Armed Forces, among others as authority for its issuance. The power to suspend habeas corpus, you'll remember, is contained in Article 1 of the Constitution, which deals with congressional, not executive powers. But Congress, which has the power under Article 1, had already spoken to the issue of habeas corpus in the USA Patriot Act, only a few weeks before. In that act, you'll recall, Congress made a point of rejecting the proposal of the administration that habeas corpus be suspended. Moreover, it laid down very specific limitations on the detention, requiring continual certification and recertification every 6 months by the Attorney General that the alien threatens the security of the United States. Minimal, but it's something. Congress also provided for the review of such action in habeas corpus proceedings, specifically, and it provided specifics as to how that's to be accomplished. So this alleged basis for the authority, power of the President, Commander-in-Chief, just doesn't cut it. It's likely, therefore, that the order, if it is used, will eventually be challenged in the courts. For under the terms of the order, even as subsequently modified by the March 22 regulations, and there were substantial modifications, an alien, not necessarily an illegal alien, any alien, by the mere fact of his status as an alien on our shores, may be arrested, held indefinitely by the Secretary of Defense with no release process available. There's no certification required of the Secretary of Defense, no right to petition of habeas corpus, and the alien can be sentenced to death, no less, with no right to appeal adverse decisions of the court, as originally adopted. Many of us, no doubt, know perfectly legal, law-abiding aliens who fall under this unfortunate category. I have a resident alien client, for example, who was just awarded the Medal of Freedom by the President of the United States, highest civilian award this country can bestow. But under the plain vanilla terms of the executive order, as originally issued, he could be subject to all of these draconian measures. He could be arrested without warrant, held incommunicado, tried by a military tribunal, simply because he's a member of this vast underclass. Something's wrong here. The second deep-seated problem I find with the November 13, 2001 order, then, is that it creates a vast underclass, in this case, all aliens, with respect to whom I determine from time to time. Well, where have we witnessed this phenomenon before and with what results? In our second session, we discussed the Alien Acts of 1798. And a number of you, having just read David McCullough's wonderful history of John Adams, may have been off-put by my criticism of John Adams, one of our great founders, for countenancing that act. But consider what happened there. The Alien Act created virtually the same underclass, all aliens, not just French or Irish aliens. And membership in that class entitled the executive, with no restraints whatsoever, save his own consideration of danger to the Republic, to detain, to punish, to deport, to act drastically. The judicial and legislative branches were removed from the equation, and the members of the underclass were at the mercy of an unfettered executive. No separation of powers there at all. When else do we experience an underclass? Well, in 1920, Attorney General A. Mitchell Palmer rounded up thousands of alien radicals who he was determined were in violation of the Alien Act of 1918. His actions were no doubt intensified as they followed on the heels of the bombing of his home, allegedly by radicals. Now, the Alien Act of 1918 was only one of a series of acts, like the Espionage and Sedition Acts, which began to develop shortly after the assassination of President McKinley at the turn of the century by an avowed anarchist. The Alien Act provided for the arrest of an alien upon a warrant issued not by a court, but by the Secretary of Labor, upon, quote, some substantial supporting evidence. The Secretary of Labor in this case was ill, and a member of the Attorney General's staff had been detailed to serve as solicitor to the Department of Labor and was empowered by this fluke to sign warrants. As far as Palmer was concerned, an allegation that the alien was a member of the Communist Party or some such organization was sufficient substantial supporting evidence, even though membership in the party was not illegal at that time. Palmer's deputy signed 3,000 warrants. And Palmer, thus armed, proceeded to violate even the basic protections of the Alien Act, arresting people in the middle of the night, seizing persons in attendance at meetings, but not even named in the warrants, holding them all incommunicado in deplorable conditions, seizing their property, keeping them apart from their families, and holding sham hearings before immigration inspectors, all based on a perception by Palmer that they were dangerous foreigners, revolutionaries. Unfortunately, in the case of the Alien Act of 1918, all of the vital issues regarding whether there was substantial supporting evidence for the issuance of a warrant were to be determined by the Secretary of Labor, or more often by his subordinates, the immigration officials. And like the executive order of November 13, 2001, where determinations are made in the sole discretion of the President, in this case in the form of the Department of Defense, there was no appeal to a court, not even to the Supreme Court. The rationale in the Alien Act was that a deportation proceeding was not a criminal proceeding and therefore involved no punishment. So a perfectly legal alien, member of this underclass, who may have lived here for many years peacefully and productively, and many had, could be deprived of his liberty, his property, his family, held incommunicado and deported without even a valid hearing or any judicial check or constitutional safeguards. How? Based on the perception of a government official, in this case by fluke Attorney General Palmer's staff or Attorney General Palmer, that his views were objectionable. The Palmer raids, it is generally conceded, were a low point in our history. Where else do we experience the phenomenon of an underclass? In 1942, we created an underclass of Japanese American citizens residing on the West Coast. Over 100,000 men, women, and children of Japanese ancestry, 70,000 of American citizens, were detained without charges, without duration, and without indictment, pending inquiry into their loyalty. They were imprisoned in concentration camps throughout the West. They were so imprisoned on the judgment of an overzealous military commander named DeWitt, pursuant to a 1942 executive order of FDR. They were punished not for individual behavior. Their only crime was a crime of status. Their status as members of a given ethnic group, members of an underclass. Perhaps the greatest anomaly arising out of the internment was the failure of the Supreme Court to invalidate it. The now infamous cases of Korematsu versus the United States and Hirabayashi versus the United States were both cases testing the validity and constitutionality of General DeWitt's military order of exclusion. DeWitt's order was based on Executive Order number 9066, issued by FDR on February 19, 1942, 2 months after Pearl Harbor, authorizing the Secretary of War and such military commanders as he might designate to prescribe military areas and in their discretion to either exclude persons from such areas or establish conditions on which people might enter, remain, or leave such areas. The operative words here, of course, are in their discretion. This was not only an executive undertaking, however. In the frenzy following Pearl Harbor, a statute was passed amplifying the order, giving it teeth, making it a misdemeanor punishable by imprisonment and fine to disobey the order. Now, in Hirabayashi, the court considered the conviction of one Gordon Hirabayashi, a student at the University of Washington, based on the act of March 21, 42, for violating 2 orders of General DeWitt under Executive Order 9066. One for failure to report to a control station for exclusion from the designated military area, which included Seattle, his home, and the second for violating a curfew within a military area. The first violation, of course, raised the entire skein of constitutional issues arising out of the forced transport of an American citizen from one of the military areas to a war relocation camp, and of his imprisonment in that camp. The court sidestepped the issue as if it never existed. It closed its eyes. It simply decided that the local commander deemed the curfew order a military necessity, and that it would not substitute its judgment for his on a purely military matter. Since Hirabayashi had clearly violated the curfew, and since the sentences for the 2 violations were concurrent, it was not necessary, in the opinion of the court, to consider the second question. Quite to the contrary. Of course, the court was free to consider the Bill of Rights issue. Of course, it was free to consider the main issue of the case, the scope and method of the judicial review of military decisions. It simply chose to withdraw, to pretend it didn't exist, to close its eyes. So what was really happening here? An organized minority on the West Coast, spearheaded by the native sons and daughters of the Golden West, a clan-like organization, for 45 years had vigorously opposed Japanese immigration and had sought to exploit anti-Oriental racial tension on the West Coast. In General DeWitt, they found a kindred spirit. And as luck would have it, DeWitt became the principal administrator of the policy and the principal policymaker under FDR's executive order. At first treading cautiously, DeWitt simply encouraged the Japanese to move away from the West Coast on a voluntary basis. This rapidly evolved, however, into a policy of forced migration, and soon a series of exclusion orders were issued which applied only to the Japanese aliens and, quote, citizens of Japanese descent, whatever that meant. Remember, the operative words were in his discretion. Questions of degree of consanguinity, to my knowledge, were never finally resolved. All such persons were ordered to report to control areas, and then they were confined to camps operated by the newly formed War Relocation Authority, an agency of the Department of the Interior. What started out as temporary accommodations until new homes could be arranged outside the military areas and loyalty could be checked out soon became compulsory imprisonment. Few were released. Even those checked and found to be loyal upon their release had to have official approval of their homes, jobs, and friends before they were allowed to move. And even upon release, they continued to remain under scrutiny amounting to parole. Officials explained to them that it was for their own protection from clan-like vigilantes. Of course, the racist vigilantes on the West Coast were ecstatic. They had profited handsomely in the absence of the Japanese Americans. The businesses of many able Japanese American competitors had simply been removed from the markets. New vested interests were being created out of the power and capital vacuums left by these interned Japanese Americans. And these interests now wielded political power they never before even dreamed of. In both of the cases, Korematsu and Hirabayashi, the court simply avoided the issue. And the majority pretended they didn't see the real issue in yet another way. They escaped by holding that the issue before them was merely the traditional test of any administrative ruling, namely, were there reasonable grounds for those charged with the responsibility for decision-making to believe that the threat was real and that the remedy was useful. The court decided in both instances that the administrative orders of the commander were based on findings of fact, which supported action within the contemplation of the statute. The so-called facts, which were thus held to afford a rational basis for decision, were that in time of war, residents having ethnic affiliations with an invading enemy may be a greater source of danger than those of different ancestry. Now, of course, no such findings of fact had been made with regard to 690,000 Italians or 314,000 Germans living in the United States. The logic was inescapable that the executive order, combined with the arbitrary amplification of that order by DeWitt, had created an underclass and a crime of status. Why? DeWitt's personal bias was certainly a major factor. When asked about this in hearings before a subcommittee of the House Committee on Naval Affairs in 1943, General DeWitt had these so-called facts to impart about Japanese Americans. I don't want any of them here. They're a dangerous element. No way to determine their loyalty. And later, when asked by the subcommittee why he differentiated between Japanese Americans and, say, Italian Americans or German Americans, DeWitt had this gem to impart to the members of the subcommittee. It makes no difference whether he's an American citizen, he's still a Japanese. American citizenship does not necessarily determine loyalty. You needn't worry about the Italians at all, except in certain cases. Also the same for the Germans, except in individual cases. But we must worry about the Japanese all the time until he's wiped off the map. In other words, our war is not being waged against the Japanese empire, it's being waged against the Japanese race. These are the so-called facts. This was the so-called rational administrative judgment, which the Supreme Court refused to question in Hirabayashi and Korematsu. So what was happening here? Judicial reasoning was being skewed to fit a framework demanded by wartime frenzy. A frenzy being driven in great part by xenophobia and abject race hatred. And the court was straining to find a rationale to justify it. The court in Hirabayashi and Korematsu simply abandoned the requirement of judicial inquiry into the factual justification for the general's decisions. But to me, perhaps the most disturbing factor present in the Hirabayashi case was this, and it's one not so evident. The court gratuitously, without any factual record whatsoever, set out to elaborate its own pop culture type intuitions about the less than perfect assimilation of Japanese Americans into American society. In his decision, Justice Stone offered this bit of homespun wisdom in discussing Japanese language schools held outside of regular school hours. Quote, "There is support for the view that social, economic, and political conditions have intensified that's Japanese American, their solidarity, and have in large measure prevented their assimilation as an integral part of the white population." It's at 320 U.S. 81. Prevented their assimilation as an integral part of the white population. I searched for parallels about unassimilable groups. I found a truly frightening one, and at about the same time. In 1940, France fell to the Germans. An accommodation of sorts was reached with the Germans, permitting the French to establish their own regime, Vichy, under Marshal Pétain, the hero of Verdun, located principally in the south of France. Pétain would soon made it clear that he wanted to eliminate those responsible for the French defeat. Prominent among the object of his scorn were Jews, the communists, and Léon Blum, former prime minister and a leading socialist figure. Blum was tried for betrayal of duty at Lyon and expelled to Buchenwald. The Vichy French were permitted their own courts, and the French, having a long established and venerable legal tradition spanning centuries, began to try the offenders. You may recall those wonderful graphic sketches by Daumier depicting French courtroom advocacy in some of its most picturesque demonstrative forms. A long, venerable, and established legal tradition. But between 1940 and 1944, some 75,000 French Jews were sent from French soil to death camps in the East. Now, Richard Weisberg, a professor of law at Cardozo Law School, in his work Vichy Law and the Holocaust in France, alleges that the vast majority of these deportations occurred under cover of French law. For as early as September and October of 1940, an independent French government, with its seat of operations in Vichy, had promulgated a widespread series of laws, regulations, and decrees about the Jews. These proved sufficiently thorough in their application and effect that the Germans largely imported them for use in occupied zone of France as well. Vichy was not considered occupied France, it was considered independent. But the remainder of France was deemed occupied. So the Germans took the Vichy laws and applied them in the occupied zone. A bizarre situation followed within French legal circles, a closing of the eyes. Throughout the 4 years of the Vichy regime, legal activity actually flourished. Weisberg points out that avocats, that is, lawyers, with greater autonomy from their government, took up the new materials of racial, religious, and ethnic ostracism and simply worked with them in volume and without substantial protest. Legal academicians wrote doctoral theses, had them published on the subject of the anti-Jewish laws, made their reputations as young law professors by discussing neutrally the stuff of exclusion, tried to explain how French constitutional norms could coexist with laws designed to persecute people ex post facto and because of immutable traits or private beliefs. Weisberg coins a term, the French legal hermeneutics of exclusion, to describe this rather unique phenomenon. Hermeneutics simply means a methodology of interpretation. The French legal profession created its own rationale, its own hermeneutics of exclusion for the legal practice it was conducting within and under a system of blatantly exclusionary, discriminatory laws. And they carried on in practice as if such practice didn't exist. For example, a bizarre twist of logic led the French bar to fight tenaciously to afford the same protections to Jewish out-of-wedlock children as to other French out-of-wedlock children. Also to afford to Jewish tenants who'd participated in the war and had been adversely affected the same protection against their landlords as was afforded to other French citizens also so affected. But at the same time, this grotesque hermeneutics of exclusion permitted the French avocat, a strategy that permitted the brain of the lawyer to read all French statutes in terms of an absence, a closing of the eyes. In other words, they just closed their eyes. The rationale? The Jews had their own laws. They were fundamentally incapable of understanding French national values. They were out already. How does this phenomenon parallel the homespun wisdom of Chief Justice Stone at virtually the same time regarding the non-assimilation of Japanese Americans? This is how. Weisberg cites the following chilling readings from a course in constitutional law at the University of Dijon in 1942 regarding the recently enacted Jewish exclusionary laws, or Statut des Juifs, the Jewish laws. Quote, "It follows from this observation that given his ethnic characteristics and his reactions, the Jew is unassimilable. The regime believes that he must be kept apart from the community." If this sounds frighteningly familiar, simply compare the language of Justice Stone and Hirabayashi. Quote, "There is support for the view that social, economic, and political conditions have in large measure prevented the Japanese Americans' assimilation as an integral part of the white population." Same time. So the French created a so-called unassimilable underclass, and the courts rationalized it through a peculiar logic which permitted them to treat Jewish out-of-wedlock children and certain Jewish tenants as privileged Frenchmen, and to close their eyes to the balance of the allegedly unassimilable underclass, sending 75,000 of them to their death in the death camps. An illegal profession with a long history of rectitude accepted this logic, pretended the underclass just wasn't there, and continued with practice as usual. At virtually the same time this was happening in France, we created a so-called underclass, incapable of assimilation into the white majority by executive decree and military order for reasons of security in 1942, pretended that we continued to keep them apart from white society for their own protection. And our Supreme Court simply stepped aside as if it didn't see the issues, as if violations of our most sacred and fundamental rights never took place. And based on this rationalization and this judicial escapism, 100,000 members of this so-called unassimilable underclass languished in concentration camp purgatory in the Golden West of this, the freest land on earth. These then are the possible unintended, but nonetheless potential lethal manifestations of an order such as that of November 13th. These are the ones that trouble me the most. I am so pleased that there was an immediate response to it in the press and in academic and legal circles that no doubt helped prompt the significant modification from the Justice Department. The phrase "aliens with respect to whom I determine from time to time" would create such an underclass. And though counsel to the President has protested incorrectly that the writ of habeas corpus has not been abolished by the order with respect to that class, it has been in haec verba, as the lawyers say, in the same words. The opportunities for mischief are endless, especially so given crisis circumstances, and if decision-making power under the order should fall into the wrong hands at the administrative level. Moreover, unlike many parts of the USA Patriots Act, there is no sunset provision in the November 13, 2001 executive order. Detention can go on forever without legal remedy. This aspect of the order, by the way, has not been cured by the regulations of March 22, 2002. The order is aimed at evil men, the worst terrorists on our planet. And it may well have been drafted with the very best of intentions. But as Zechariah Chafee wisely pointed out with respect to the infamous Palmer raids, a law is much more than its words. It's what human beings do with those words. We have witnessed the stark reality of this with A. Mitchell Palmer in 1920, General DeWitt in 1942, abroad with Marshal Pétain in 1940, and at home with Joe McCarthy in the 50s. When the separation of powers is in severe imbalance, as it is under the November 13th order, and the judiciary abdicates when crisis times prevail, as it did in Hirabayashi and Korematsu, there is danger that the unbridled discretion given to such men will create an underclass and devastate their freedom in our frantic search for security. In studying the conflicting demands of freedom and security, if I've learned one thing, nothing else, it is that there are no simplistic answers, no simple solutions. I wish there were, but there aren't. One of the burdens our founders left us was that we must seek the harder, more complicated solution. Simplistic answers are the prerogative, of course, of the closed society. A Hitler Germany, a Stalin Russia, a Hussein Iraq need not be troubled by these problems, but we must be. I chose to focus on the order of November 13th, 2001 in this, our last session, because it is in many respects just that, a simplistic solution. An overreaching, which if followed to its logical conclusion, could lead to a great injustice for many. If those charged with administering it are not persons of good intentions, if they're a Palmer, a DeWitt, the executive order of November 13th was an understandable reaction. The administration was charged with the protection of our free society from a vicious, clever, but depraved form of fundamental Islam, which considers itself morally superior to the West, but is enraged that it is backward, materially inferior to the West. And the administration lashed out amid an atmosphere of fear, national crisis, and xenophobia when it felt that its efforts at securing our society were being thwarted. Understandable. But in so doing, in issuing such a blanket order, it made possible, perhaps inadvertently, to sweep up a vast group of innocents in its web and into a nightmare of Kafkaesque proportions. Read yesterday's Times. But we are charged with a higher duty. We have a burden. We must seek the complicated solution. So far, there have not been any military tribunals. So is all of this still relevant? Very much so. The issue is far from moot. Just this week, the trial of Zacarias Moussaoui, an admitted member of Al-Qaeda and an admitted devotee of Osama bin Laden, who was accused of complicity in 9/11, faced a critical problem. The record has prudently been sealed by a careful federal district court in Alexandria, Virginia. Leonie Brinkema, very good judge, for security reasons. Much care has been taken that there be no inadvertent release of classified information. But the seminal issue, which was reached just this week, is one of many issues which will test whether we can be sufficiently ingenious and sufficiently dedicated to protect both our freedom and our national security. The issue is simple, the solution complex. When Ramzi bin al-Shibh, an important al-Qaeda operative and one described as a ringleader in the September 11th attacks, has been caught and is being interrogated as we speak by our intelligence. The complaint in the Moussaoui case alleges that al-Shibh wired $14,000 to Moussaoui from Germany in August 2001. Moussaoui's court-appointed lawyers understandably want to interview al-Shibh. The Justice Department is justifiably concerned that our security will be seriously compromised if defense lawyers are allowed to exercise Moussaoui's Sixth Amendment rights to seek out witnesses such as al-Shibh, who can allegedly bolster his defense. Moussaoui, you see, claims he had nothing to do with September 11th, and that the witnesses such as al-Shibh will confirm this. This kind of issue is already bringing rumblings from the Justice Department that it may pursue future prosecutions in military tribunals. But we must not jump to such simplistic solutions. The test is for us to wrestle with and solve the complexity with as ingenious solutions as our best legal minds can fathom, to protect both our freedom as well as our classified information and our sources and our security. That is the greatness of our country, but it is also the cross we must bear in our free society. I'm confident we'll solve this one, as we have successfully solved this problem in a number of terrorist cases before. But there are no simple solutions. So we've come a long way together in these 6 sessions. We've seen how our forefathers bequeathed us a great doctrine of freedom and how they enshrined it in a magnificent constitutional system, flawed perhaps, but undoubtedly the best system yet devised in this very imperfect world in which we live. We must be forever vigilant that in guarding our security, we do not lose the very freedom we seek to safeguard. That in pursuing the terrorist, we do not allow ourselves to become as indistinguishable from him as was the naked policeman from the naked Doukhobor. For then we shall have lost our soul. We shall have lost everything. But despite all of the historical pitfalls we have considered in these sessions, I remain convinced there's a fundamental greatness to our country. We are a people like no other on the face of the earth. Though as a people we may stray, we are a people with an openness, good nature, an abiding sense of fair play, and a willingness to correct our mistakes. We may falter, but I have faith that we will ultimately find the right solution. Why do I share such faith in our people? Because through it all, we're a free people. Remember when we started 6 sessions ago? We are a people forged in the Mason image of our founding fathers. A people free to reflect, free to choose, free to think, free to express and to ponder and to debate. It's a virtue that defines us. And although our collective minds may often go astray, given the opportunity to observe and reflect, our free minds will eventually grasp the truth. We may be misled from time to time by Huey Long, or Charles Coughlin, or Joe McCarthy, but only for so long. Our founding fathers not only bequeathed us a basic faith in the dignity of man, but a cold, hard common sense about his actions. And eventually, in a free society, this common sense will find its way to the surface. Moreover, we must never forget that we are a work in progress. I share another insight of Roger Rosenblatt in this regard. Quote, "This country is a continually, if reluctantly, improving entity. The America I heard singing when I was a teenager in the late 50s forced homosexuals into hiding, ignored or derided the disabled, withheld rights from suspects of crimes, kept women in their place, which was usually the kitchen, sometimes an abortionist's back room. It foisted prayers on school children, paid no attention to the health needs of the impoverished or the elderly, endangered endangered species, threw people out of work because they held what was considered to be an un-American ideology. In certain states, it denied black Americans the right to sit where they wished on a public bus, to drink from a public water fountain, to eat in restaurants, stay in hotels, go to public schools with whites, or vote. Tell kids all this today, and they think I'm talking about another country. I am. Notwithstanding all the deviations we've discussed in these sessions, I continue to have faith that our people will not ultimately be deterred from the path of freedom by crises or xenophobia or temporary cracks in the armor of the balance of powers. The mere fact that we're meeting here today, studying these flaws, discussing these weaknesses, bears witness to the health and vitality of the system we live in. I pray that this is a phenomenon that we will pass down to our children and their children and to the many generations yet to be born. You've been a great group. God bless you all, and thank you.